Hello, everyone. I'm Tanya Rivero in New York, and this is an ABC News digital special report. The Supreme Court has passed on making a sweeping decision on the future of affirmative action in America. The case ruled on today, Fisher versus the University of Texas, has been sent back to a lower court for further consideration with strict instructions from the justices in Washington. The ruling came in at 7-1. Ginsburg in dissent. Elena Kagan has recused herself from the case. We're joined now by ABC News' Terry Moran. Hi there, Terry.
Hi there. Good morning to you from a muggy Supreme Court.
Yes, thank you, Terry. First of all, what was the lower court's ruling, and is it now expected that they will change that?
Well, the lower court said the University of Texas was permitted under the Constitution to use race as one criteria in the admissions of students after they'd already admitted about 80% of their student population on what they call the top 10% program. If you finished in the top 10% of your high schools in Texas, you got in. Then they wanted to add more diversity, which is constitutional, and so they used an applicant's race as one criterion. And that, the Supreme Court said today, was not given sufficient scrutiny by the lower courts. Now, that's a suspicious thing to do under our Constitution, using race for anything. And therefore, the lower court needs to make sure, and this is where the tough language is, in a very gauzy opinion. Justice Kennedy says, the court must be satisfied that no workable race-neutral alternative would produce the desirable educational diversity. You got to show there's no other way. That's a little tougher on the schools that are using these programs, and so we'll see what the lower court does with that. But one piece of evidence that they didn't do a lot today, it was a 7-1 decision. If you got that many of these justices agreeing, it's not going to be that controversial.
Absolutely. Tell us a little bit about the dissent, Ginsburg.
Well, Justice Ginsburg clearly is an advocate of the constitutionality of these programs, and she said, under our precedents, the lower court did the right thing. The University of Texas came in, said, here's our program, here's why we're doing it, here's how it works, it squares with your law, we aren't using a quota, we aren't using a numerical system, we're taking into account the holistic attributes of each individual applicant, and race and their background in that way is one of those. Justice Ginsburg said, that's what we've asked these colleges and universities to do. The University of Texas did it. The lower courts interpreted the law correctly. I wouldn't send this back at all.
All right, so today we have sort of an anticlimactic ruling as it is going back, you said, to the lower courts. But what is at stake here ultimately, Terry? Is this a battle over who ultimately decides how the universities look, the courts or the universities themselves?
That's a good way of putting it, that this is really a struggle over what our colleges and universities and, frankly, our places of employment and the government contracts, all those things which have been affected by this effort to redress the wrongs of hundreds of years of racial discrimination, the continuing racial discrimination in our society by the use of race. Who's going to decide that? For decades, the court has said you can use race, but they keep narrowing it because it bothers a lot of Americans. It's a deeply unpopular program, polls show, and at the end of the day, this court will be asked yay or nay for once and for all, but they didn't do that today.
Of course, I mean, I don't think there's anyone in this country that wants to use race as a grounds for admission, but the question is whether it is still needed, right? That's where the question is. Can you give us a little more background on this case? It certainly spent a lot of time in the courts.
It did. It's a young woman named Abigail Fisher, who's a white woman, a young woman applicant to the University of Texas. So as I said, Texas has this program, top 10%. If you finish in the top 10% of your high schools, you get in to the university system. That increased diversity in the Texas colleges to about 8% of the student population. The minority population, the African American population, is 10% in Texas. So after admitting 80% of the students, the last 20%, they said, we'll take race into consideration along with your family background. Are you a military family? Are you a legacy? All these other things that they take into account will also look at the individual's racial background. Abigail Fisher didn't get in. She says, that's unfair. That's racism against me, a white applicant, and I don't think that's constitutional. And her case goes on now.
You did bring up a good point, though. As you said, there are other things that are taken into consideration, including legacy and perhaps how much a family has donated to the school. So, I mean, those things aren't necessarily fair either.
Right, there's all kinds of things that a school can legitimately take into account in admitting. If you can run a 4.40 and you're 6'1" and 230 pounds, the school will take that into consideration to admit you into the school. But they can't take into account race, and that's obviously because of our history of race and our Constitution, which is no person shall be denied the equal protection of the laws based on race.
Sure.
That's the 14th Amendment. And so while that was written to combat the vicious white racism of segregation and slavery, white applicants now believe they are being disadvantaged because of their race, and that's where we are.
Absolutely. Now, so could this case end up back at the high court once it goes back to the lower court?
It could. It could. This is an issue that will come back to this court, whether it's Abigail Fisher's case or whether it's somebody else's case. At some point, this court will have to really bite the bullet and say, yes, because of our history and because the way this is being used, it's okay, or no, let's be done with classifying each other on the basis of our race.
And so what's the timeline here? What were the Supreme Court's specific requests of the lower court? Do they have to start hearing this case right away?
Well, you know how courts work. The lower court will get this opinion. They'll read it. There's not a lot of guidance in here. And they'll go at it again. And it'll percolate. That'll take several months. And it'll percolate, if it does, back up here a year or so. I mean, at the very least. The wheels of justice grind exceedingly slow, as
yes,
they say.
Indeed they do. But does this mean anything for affirmative action policies at American universities now? Will we see any changes?
That's a great question, because every university lawyer was looking at these opinions, waiting for them to see what they could do with their programs. And there will be tinkering. Guarantee every university and college president in the country is saying, what does this mean for us? And they'll look at this and they'll say, you know what? We have to show that we've tried every other alternative to get the diversity of our student population that this court has said is a legitimate goal for educational purposes. And we've tried everything else, and so we have to use race in this way. It'll toughen the standards at various colleges for using race.
And Terry, there was another case in question here, the University of Michigan Law School decision. That was also on the line. Was there any mention of that?
That was the precedent, one of the last big opinions of Justice Sandra Day O'Connor, in which she said, we still need to use race in admissions. She said, for about 25 years, she just kind of picked a number out of her hat. This was 10 years ago, so I guess it's got 15 years left. They did not overturn that opinion. They said, that's still good law, but you didn't interpret it tough enough. Go back to the drawing board. All
right, and back to the drawing board we go indeed. Well, thank you, Terry Moran at the Supreme Court.
Thank you, Tanya.
And we turn now to ABC's Rick Klein at the D.C. Bureau. Hi there, Rick. Can we expect any reaction from the White House today?
I think you're likely to see the White House silent on this. The president is a big supporter of affirmative action. If they put out any kind of statement, though, I can't imagine that they'd get into the details, given that this was a punt. As Terry pointed out, a 7-to-1 decision tells you about all you need to know about the politics of this. This is relatively non-controversial in that it's going to be sent to another court. So whatever tea leaves we're reading, whatever signals they're going to come out of this, whatever policy changes come out of this, I think it's clear that these things are going to come back to the Supreme Court in another year, maybe 2 years, and we're likely to see a lot of the political figures kind of hold their fire in the interim.
And Rick, has President Obama made any major comment on this case previously?
His administration weighed in. They wrote a friend of the court brief supporting existing policies, supporting the right of universities, colleges and universities to use race as a factor in admissions. They want that precedent to stand. A lot of President Obama's supporters aligns very much with the Democratic Party's support for affirmative action generally. There's an array of mostly Democratic politicians who will be the first to say, or among the first to say, that they benefited from affirmative action policies earlier in their career. The Castro brothers, one is the mayor of San Antonio, the other one is a congressman from Texas. They both say that they wouldn't have gotten into Stanford without affirmative action. So it's credited with advancing the careers, the lives, the legacies of a range of major political figures, and it's been part of the cultural landscape for decades now. Right. So it is a hot-button issue, and any tinkering with it is going to draw a widespread disapproval from one side, approval from the other side. But again, because this kind of leaves things in place, freezes things for a little while, I don't expect there to be huge political fallout in the short term.
Sure, absolutely. But now that the case is back in the lower courts, is this debate over affirmative action effectively put on hold for a while?
Yes, but it'll be back in only a short hold. As Terry said, wheels of justice are slow, but they are continuing to move. There is no doubt that whatever result is reached at the state level in Texas is going to end up back before the Supreme Court, because we know that these issues, with a changing court, with changing society, with changing times, and in fact, in this case, the way that the precedent was written, it anticipated a time where race would no longer have to be used as a factor in admission. The Chief Justice, John Roberts, has written before that the way to stop discriminating based on race is to stop discriminating based on race. So there's a cohort, a segment of the justices who very much want to be rid of affirmative action. There's a different coalition that could emerge that would, again, make it more strict in terms of interpretation, make it harder on colleges and universities. But clearly this is something that's moving as society moves.
Right. I mean, I would think that everyone holds that as the utopian goal. The question is, have we achieved that yet? Now, the justices have, by a pretty significant majority, asked the lower court to reconsider their decision. Which way is this issue pointed now? I mean, the pressure seems to be on the lower court to be more pointed and more careful in their decision.
That's right. It seems like the high court has said, look, you guys just kind of waved this through at the lower court. So next time you look at this, make sure that race was actually the only way that they could do it. As in this case, very important to note, Texas has this 10% rule, which does bring diversity. It is a constitutional way, undoubtedly constitutional way, to bring diversity to their ranks, to say, if you go to a high school in Texas, you're in the top 10% of the class, whether that is the poorest district or the richest district, the all-white district or the all-minority district in an inner city of Houston or Dallas or Austin or San Antonio, you get into the University of Texas, to the biggest and most prestigious state school in that system. The question is whether they need another layer on top of that, of explicitly race-based affirmative action, whether that is among the vast menu of things they're allowed to take into consideration. So look, it's interesting on this. The public seems to be over affirmative action. If you ask them, it's 3/4 of the public saying they don't think race is a valid criteria. And that's something that's actually held steady over the last couple of decades. Whether we've advanced as a society, whether the justices' interpretation of the Constitution has evolved over time will be the question ultimately when it reaches the court again.
Absolutely. And Rick, we are still waiting on two major decisions, the gay marriage cases. Any sense of when we will get those rulings?
It's not just that we've got two separate ones on gay marriage. One is whether a state has the right to ban gay marriage via the ballot boxes have in California. The other, the federal government's attempt to define marriage as between only a man and a woman. So there's two separate ones on that. And then there's another one that reconsiders the Voting Rights Act, one of the signal achievements of the civil rights era. Whether that is constitutional, whether it needs to be tweaked to adjust to changing times, the key questions there. We know that the court will be back tomorrow. This is supposed to be the last week that the Supreme Court is in. So the anticipation is that both of those major issues, the two gay marriage opinions and the Voting Rights Act, will be resolved by Thursday at the latest. But the fun thing about being the Supreme Court is that you can kind of make your own rules and no one tells you otherwise. So there's always the possibility that they're back again next week.
That is the fun thing about being the Supreme Court, but it will be a busy week for us in the media. Rick Klein in Washington, thank you so much.
Thank you.
And for more on the Supreme Court's ruling on affirmative action today, you can go to abcnews.com. This has been an ABC News Digital Special Report. I'm Tanya Rivero in New York.